But I think it's very clear that there's a public interest standard that the FCC is charged with. And this has a lot to do with the interest of the public in the country. This isn't just about getting into some menacing details just to be complex and complicated. Would you like to comment, Mr. Pierce?
I didn't address this in my prepared testimony because it struck me as an issue of substantive communications law, and I'm not an expert in that. I will change hats, though, and tell you I am an expert in antitrust law. That's another subject I've been teaching for the last 30-some years. Mm-hmm. And I agree completely with Mr. Benjamin that it would make a lot of sense to take the FCC completely out of this. The FCC doesn't know much about antitrust law. The FTC and the Department of Justice know a lot about antitrust law. They have the power to impose conditions. They regularly impose conditions on mergers. Those conditions are specifically tailored to address the competitive issues that are raised by a proposed merger. That's something the FTC and the Department of Justice Antitrust Division know a lot about, and the FCC knows very little about. So I agree completely with Professor Benjamin that the far more sensible thing would be a statutory change that would probably require about 10 words that says the FCC has no power over mergers. That's exclusively the realm of the DOJ and the FTC.
Mr. McDowell, I'll go to you, but I have to excuse our colleagues. We're down to 5 minutes.
Anyway.
So go ahead.
Seconds. I think actually there's an emerging headline right here, which is I would agree.